Good afternoon and welcome to Global Law Assembly Conference 2021. Today's panel discussion is on strengthening multilateralism beyond OECD G20 for tackling base erosion and profit shifting for tax avoidance practices. I'm Bhavna J, a principal researcher for IGlobal Legal Research and Media. I'm joined here today with two esteemed panelists, Mr. Pallab Pradyuman Narang and Mr. Parth Saratija. Mr. Narang specializes in direct tax advisory and business advisory services, and he's also a partner at CNKRK Chartered Accountants. He's also an ardent writer and has authored several materials on taxation and tax structuring. Our next panelist, Mr. Parth Saratija, is a partner at Economic Law Practice. His focus areas are on international trade and competition issues. He also regularly advises the Government of India on rights and obligation under the World Trade Organization. Today, we will be discussing he will be discussing the international trade aspects under the BEPS regime. I would like to give a small brief upon the subject before we delve into the discussion. The 2008 financial crisis and the successive tax scandals acted as a wake-up call for the globalized economies, which brought about many benefits to the world. But governments realized that they needed to tackle tax evasion and tax avoidance, which promoted a strong sense of unfairness. Bank secrecy and lack of transparency helped high net worth individuals to hide their assets offshore. Loopholes in the international tax rules also allowed multinationals to artificially yet legally shift their profits to low or no tax jurisdictions, resulting in low or no overall corporate tax being paid, or commonly in tax havens. International cooperation and multilateralism were vital to introduce some form of tax regulation in globalized economies. The BEPS framework is to improve and ensure the transparency. This includes alignment of taxation with location in which the economic activity is being carried out and the inception of commonly agreed tax administration across various countries. Further, the panel discussion will also address and raise questions on how the current BEPS regime would impact international trade between countries. The scope of the panel discussion is divided into the following themes: OECD International VAT GST guidelines, the interface between tax laws and how it affects international trade, how countries and governments can coordinate and make changes in domestic laws, treaty shopping through letter companies and how to stop them. The purpose of the discussion is to understand how companies in India and Indian individuals and firms would be impacted by the current BEPS or base erosion and profit shifting tax planning strategies used by multinationals to exploit the tax gaps. BEPS is of utmost significance for developing nations such as India due to its reliance on corporate tax. The tax strategies existing can affect the fairness and integrity of tax system in place, since the businesses that operate across borders can give a competitive advantage over companies that operate domestically. So, moving on to the discussion, considering that this is fairly a complex topic, I request you to begin with providing your insights and explaining how base erosion and profit shifting tax practices work. Further, it would also be great if you could elaborate on the multilateral and international efforts that are in place for tackling base erosion and profit shifting.
Since I'm the tax guy, so I imagine this is headed
Yes.
towards me.
Yes.
So a simple way to look at base erosion and profit sharing is, to just take a look at any one of these large multinational digital companies. Imagine a digital company, say Facebook, which is headquartered in Ireland. Facebook earns a lot of revenue from India from its advertising activities in India. It has a substantial user base in India, and other than these small entities that they have for development, etc., Facebook pays little to no tax in India on the advertising revenue that it makes from India. This is a clear example of base erosion and profit sharing, where an entity headquartered outside earns substantial revenues from India but pays little to no tax revenues in the country, the market jurisdiction where it earns this revenue from. India has obviously taken some steps to curtail this particular practice, but yeah, given in the context of our conversation, I think this is a second example of what this base erosion and profit sharing entails. So basically, as a matter of policy, the large countries around the world have gotten together. G20, OECD have formed a group called BEPS to tackle this particular practice, to ensure that taxes are collected by market jurisdictions as well, and somehow because the treaties that have been that were signed earlier, the treaties that most of the countries have, bilateral treaties, the double tax avoidance agreements that most countries have entered, they were signed in an era which predated digital businesses, and hence have not been updated or do not reflect the business realities as on day to day. So therefore, the BEPS initiative aims to, through its multiple pillars, address this particular situation and see how businesses can pay tax fairly across jurisdictions.
So we have looked at that most of the methods that we use which are indulged in base erosion profit shifting are not exactly illegal. However, some of them are illegal. So across the various jurisdiction, how fair is it for multinational corporation to be subject to the scrutiny by authorities under the BEPS framework or regime?
So, I mean, see, I always, tell everyone, including my clients, that tax planning is your right, but tax evasion is a crime. So, multinational companies and all businesses of all sizes, have a right to legitimately plan their taxes for a favorable outcome, for a favorable cash flow position from a business perspective. Multinational companies have an advantage in the sense that they can choose to locate themselves in jurisdictions which are lower in taxes as compared to other countries. Developing countries, for example, might need additional tax revenues because of their needs, because they have a lower tax base, etc., as compared to developed nations. Now, developed nations, on the other hand, tend to feel, that since they have collective, IP, etc., and they need to be earning a fair share of revenue for the IP that is housed in these particular countries. And multinational companies are able to house themselves in low tax jurisdictions, such as Ireland, etc., and not pay tax on any of these places, either developing countries or developed countries for that matter. So even though it is within the contours of the law, given the context, given the market, it may not necessarily be ethical. So and this is something that we can discuss till the cows come home, that legality versus ethicality of the entire exercise. Like I mentioned earlier, most of these treaties were enacted, the double tax avoidance agreements were enacted before the internet age, and new business models are challenging the thinking embedded into these particular treaties. The main issues that countries would like to address are global tax laws, the fact that market jurisdictions contribute substantial money but don't get any revenues in return, and developing countries get hit the most because their tax base is already low, and multinational enterprises, these MNEs, take away a large chunk of money from these entities without contributing any tax revenues.
Since you were focusing on various pillars of how the BEPS regime work, can you provide your insights on the statement made about the two-pillar solution to address the tax challenges arising out of digitalization of economy, which has witnessed an interest from about 130 countries right now. So, do you believe that the solution will actually affect the BEPS regime or practices in any manner?
So they've been, July has been a particularly interesting month from a BEPS perspective. First the G7 countries announced a historic landmark tax deal amongst themselves, and then some days later the BEPS two-pillar solution also was announced. So basically, to simplify things, the two pillars address one, a special purpose nexus rule to allocate profits of high revenue multinational enterprises to smaller jurisdictions. So if, let's say, a business which is making more than 200 million euros, sorry, I forget the exact figure right now. I believe it was 20 billion euros. So any entity earning more than 20 billion euros and paying less than 10% tax rate will be subject to this particular 10% margin, rather, is subject to this. And if, as long as they're practicing in jurisdictions and earning more than 1 million euros in each particular jurisdiction, they will have to allocate certain amount of their margins to this particular jurisdiction. And in case the market jurisdiction where they earn this money from is less than $40 billion euros again in GDP, then this threshold is lowered to 250,000 euros. Pillar 2 basically talks about GLOBE rules, which are the global anti-base erosion rules, and the subject to tax rules. These are rules, which will talk about, basically allocation of profits from one jurisdiction to the other, adjustment of income inclusions. So these are similar to the guilty provisions that the US had enacted 2017. So these two pillars effectively ensure, that excess profits of a multinational enterprise get taxed equally in market jurisdictions as well as the source, as well as the headquarter jurisdiction wherever these businesses are located.
So, do you think that this would place like a difference in the digitalization of the economy today? The regime that is being introduced right now.
So, if I understand this correctly, your question is that whether this will affect the digitization of the economy as we are seeing today.
Yes, yes.
I don't think so. I think we are on a path of no return. I think the internet age is well and truly here, and we're not going back to. Facebook is not going to set up headquarters in every country. They're going to be charging revenues from a centralized source. They would have intellectual property and shareholders to report to, right? So we're not going to see a decentralization of this internet economy. We obviously have several decentralized initiatives such as Bitcoin, etc. But I mean, they work in a different different field, different set of markets, not even markets, different set of circumstances would be better. So yeah, so the internet economy is very, very much here, and I don't think these measures are going to dissuade the internet economy in any particular shape or form. What's going to happen is perhaps that the profits from the internet economy are going to be distributed or taxed across jurisdictions slightly more fairly. And to be honest, if the US or the other large economies, where these companies originate from, were getting their fair share of taxes, we would have never seen this particular set of changes. The fact that the US also is losing out on tax revenue to countries such as Ireland and Netherlands, is the impetus for these changes. India or other smaller countries could scream, as much as they like, but the larger countries will obviously have, their way as far as these particular measures are concerned.
Thank you. So we'll be moving on to the trade aspect. So I want to ask, considering that taxation is a key aspect in assessing the location or economic benefits for any international investor, taxation and tax relief are usually fiscal incentives that are offered to increase international trade. As a result, do you think there is a nexus between how the current BEPS regime would impact international trade between countries?
Yeah, thank you, Bhavna. If I'm still audible, do let me know if I'm not audible. Just to respond to your question, tax and trade will have and always had, for that matter, a relationship, deep relationship when it comes to movement of capital, when it comes to movement of goods. Now, unfortunately, what has happened historically is that somewhere trade and tax have been seen in silos. So in a post-World War II regime, when you had the Bretton Woods, institutions, you had WTO as a trade body, but you could never had an international body which will look at the tax. Taxation has been always left at some level, I would say. Of course, OECD is one example, which is not so hard as WTO as an institution is. It's more kind of a body which creates this soft legal principles. People voluntarily abide by that, but it does not have the same level of hardness or enforcement as a WTO will have, right? Again, you have these. I will defer here to Pala, but taxation has been mostly looked bilaterally between countries when you have these double taxes and avoidance agreements and similar sort of arrangements. And most of them over a period of time have become standardized. Like you have same set of languages, same set of coverages with slight differences, slight variances. So unfortunately, these two have been looked differently. Well, when there is a deep nexus between taxation and trade, because as we know, the whole issue of base erosion, which Pallav very, very helpfully explained, there is this tax competition between countries, right? And in order to attract investment, you come out with these measures where you have no taxes or very less taxes compared to your competing jurisdiction. Now, movement of investment, which cities you will choose to produce products and then sell it in the global market. This is very much at the core of the WTO as well. Yet you'd see that WTO could not have a broader set of agreement on investment disciplines, right? That discussion is happening since last 25 years now, and we haven't moved an inch on that. What you got was something which is completely useless, I would say, TRIMS agreement. And TRIMS agreement is nothing more than what is already in GATT 1994. It doesn't add anything to that. So the only to the limited extent where the WTO could incorporate the issues around tax was basis the non-discrimination principle, and that pretty much is incorporated under Article 3 of the GATT. Now, even there are different views under Article 3. There are commentators who think or who view that it doesn't deal with direct taxes and it only deals with indirect taxes. Now, I will not get into that academic debate, and it's not so much anymore academic after Argentina financial services dispute, which happened in 2016, and the entire academia and trade practitioners were looking at anticipation of the outcome of this dispute. But that was outcome was quite dampening in that sense. But there is a view that the entire national treatment obligation, which you have, mostly deals with indirect taxes and not so much on direct taxes. At the same time, the US FSC case, which was under Article 3.4 of the GATT, and if for the benefit of viewers, Article 3.4 is nothing but it's again a manifestation of a non-discrimination principle, that you don't disturb the competitive conditions between a like domestic product and a like foreign product basis in a manner through your internal laws, so as you afford more protection to your domestic like domestic goods, right? And US FSC Foreign Sales Corporation is one case where a direct taxation regime was held to be violative under Article 3.4, because Article 3.4's language is very wide. Unlike Article 3.2, which deals more on internal taxes, Article 3.4 is more about internal laws, regulations, etc. And laws, regulations are very wide. So to that extent, if there is a distortion between the competitive conditions for a foreign like product, like product itself is a very complex issue in international trade. But if likeness is established, so if there is a distortion between the competitive conditions on the foreign like product and the domestic like product, and if you're offering more protection or if you're distorting the competitive conditions to the detriment of foreign like product, to that extent WTO will come into picture. But beyond that, it's unlikely that WTO will do anything more. As we see in Argentina financial case, appellate body at some level, some commentators believe that showed a level of deference to the parallel tax reform, which is already going under the OECD, and therefore refrained and to an extent, basically set aside the panel's finding without providing much rationale. Although it was not on GATT, it was on GATS, but it was a good opportunity. And GATS, you'd see, GATS, the distinction between direct tax and tax is much more, indirect tax is much more pronounced in GATS vis-a-vis which deals with services, vis-a-vis GATT which deals with goods. So yes, to answer your question, there is a relationship. That relationship historically has been only limited to the issue of competition and how tax regimes can actually inhibit flow of goods between two countries. Nothing beyond that at the level at what OECD and G20 have currently came out with this inclusive framework. I hope that addresses your question.
Yes, sir. Sure. So since we are talking about what the domestic countries are doing in order to implement BEPS measures, so what do you think India has done so far to implement the BEPS measure under its domestic legislation? And would you consider or treat these measures as sufficient? It would also be great if you could highlight what other countries are doing apart from India as well to implement the BEPS measures.
Is that a question to me or Pallav? I can briefly answer that question.
Anybody can take it.
Yeah,
Sure.
so but I mean, again, deferring to Pallab because again, more it's a taxing issue. But to my mind, I mean, I'll just put my brief remarks on BEPS, India's digital tax and equalization levy, which came. That could be perhaps one example of manifestation from India's side that why it wants to tax certain companies. Now, to what extent that articulation was right, I will not get into that. We all know that there was a investigation by United States under their domestic law, which is called Section 301 Act. Again, that action which United States only came out with the study has not taken any act. If it does take any unilateral acts under Section 301, to what extent that itself is a WTO consistent measure is itself a questionable issue. But I believe equalization levy is perhaps one example of somewhere addressing the issues of BEPS, and India is not alone. There are other countries in Europe which have done. France is there, Italy is there, and there are other countries who have taken. And I think this whole framework which has come with this large, I would say, agreement of almost 130 countries, at some level these individual actions which different countries have taken quite well be addressed now. But I will stop here, and maybe Pallav will answer this question.
Well, just wanted to add, that the actions that India has taken are not outside of the BEPS framework. Equalization levy, SEP rules, and withholding taxes. All of them are addressed in the Action Plan 1, as far as the BEPS rule are concerned. So, while India was one of the first countries to adopt it, these are not measures that India has thought of unilaterally. These were very much envisaged as far as the OECD BEPS plan is concerned, and have been signed off by the OECD countries as well. It's just that India took a lead in adopting these measures to protect tax revenue, and the US may not have been adequately prepared, or there's no credit on the US side for some of these particular measures, and that's why we saw, at least not against India, but we saw trade retaliation against France for similar taxes that France had imposed, for example, and this is something Parthasarathy already alluded to.
Could you elaborate on what the measures that India has taken till now in order to implement the PEPs?
So India is basically, in terms of we already have withholding taxes under Section 195 on any payments made to non-resident entities. Other than these measures, what India has done is India's basically imposed two things, which is equalization levy, and has announced the significant economic presence, or ACP rules. Equalization levy was announced earlier on advertising revenue. So basically, if Google and Facebook were earning advertising revenue from India ensured that there was a certain minimum of tax, that would be deducted from these particular revenues and retained in India. Unfortunately, what actually happens in terms of the implementation is the tax is borne eventually by the Indian customers, and other than some players, most players don't really provide this particular credit to the customers. But the intent is to retain a certain element, and to earn a certain percentage of revenue from digital advertising revenue that is generated from India. Equalization levy has been extended now towards goods sold from India. So e-commerce operators sitting outside India who earn a revenue from India above a certain specified threshold will also be subjected to similar equalization levy. So the second aspect is the significant economic presence rules. The significant economic presence rules detail out basically on the basis of number of customers, or the revenue, or the views that a website or a business might have from India. Defines a certain threshold, and if, let's say, foreign businesses which do not have a physical presence in India, so think of will be deemed to have an economic presence in India, and will their incomes generated from India will be subjected to tax in India. SEP has been likened to be like a virtual PE, so wherein the PE concept, the permanent establishment concept, had a physical connotation to it. You needed to have physical presence in India, either through an office or through an individual or an agent, as the case might be, to have a permanent establishment in India. Now you can have a permanent establishment in India without actually having any individuals or feet on the ground. So this is a sea change from the earlier regime. Having said that, significant economic presence is outlined in the domestic tax law, and can still be overridden by DTAAs, which have still the old concept of permanent establishment embedded in them. What India is doing, not just India, in fact, all OECD countries are doing is, the MLI framework, the multilateral instrument framework, which is then, accentuating the DTAA that have already been entered. The MLIs will then add to or contribute to, the DTAAs, in a sense, that they will bring them up to date, and these companies, these multinational enterprises, and these concept of significant economic presence, etc., are enshrined in the MLIs, and the MLIs, by that particular modification, they'll provide a international framework to SEP rules, etc.
Thank you so much. So the next question is, since you're working tax professional, what are the daily challenges that you would face as a professional while dealing with clients who come about with BEPS issues, and what reforms would you propose in making this process more equitable for companies and governments?
So this is a difficult one, because different set of enterprises will have different set of challenges. But ultimately, one has to look at, which entity or which jurisdiction, are we representing. If, let's say, we're representing a multinational enterprise based in Ireland, which is going to, perhaps lose out on tax benefits, the challenges are going to be different, versus an Indian enterprise, which is a customer of these multinational enterprises and then has to deal with, equalization levies or, other withholding tax levies. The challenges are going to be different. So again, there is no one size fits all approach. Each individual business has different needs, different challenges. Multinational enterprises, which are spread across multiple jurisdictions, will have different, pain points depending upon, the structure, etc. So I am sorry, but I don't think I have, a one cohesive answer to this particular question. Sorry about that.
Yeah, sure. No. But do you think that it's sort of challenging now that for you to deal with clients who come about with problems regarding the BEPS regime or issues if they come about in the future?
I mean, I don't think it's a challenge for us, right? That's what tax professionals live for, So this is a, we welcome these challenges, and we're happy to deal with them. So I don't think this is a problem area per se. It's an opportunity for global businesses to look at how they're doing business, where they're located, and we maybe address some of the tax issues basically address some of the tax structures rather that they had built in the past, and relook at the positions, and take a look at the overall tax rates that they're going to be able to pay in the future. So going back again, tax planning is a legitimate right. Tax evasion is obviously not. So I think businesses have to relook at their tax positions that they've adopted and align them with the new realities that BEPS and the ensuing outcomes present.
So, how do you think that multilateralism can be strengthened beyond the OECD G20 for tackling BEPS practices that are usually over tax avoidance? How do you think that multilateralism can be strengthened beyond this measure?
So I think part of this question will go to Parthasathi, because multilateralism from a trade perspective is something that we haven't seen so far, and I think Parthasathi would allude to the multiple treaties, trade treaties, etc., that are going to be happening, especially in the context of Brexit, etc. But yeah, from an OECD G20 perspective, ultimately countries will look at their own financial interest. So multilateralism, the MLI instruments that we have is, I think, any which way is a groundbreaking event, in taxes. And each country will want to be able to tax these global giants, on the source, on basis source of their revenue, any which ways. So I am not an optimist on multilateral measures, or strengthening of the global economy per se, in terms of coming together. Like I mentioned earlier, the G7 moves are also precipitated by the US in terms of the tax loss that the US had. It's not like the other countries had a lot to say about it. So yeah, once precedent is obviously established by larger countries, once OECD and PEPs lay out action plans. For example, individual countries will take measures independently based on that precedent.
So,
Parthasat, you might add to this point.
Yeah.
Yeah, and thanks, Pallab. I mean, that's a good question, and it's the question. I mean, begs consideration from various angles, including geopolitics. So, if you look at, it's after a long time that we have seen a forum where multilaterally people have come to a conclusion, right? The United States, the Trump regime at some level had completely distorted the whole multilateralism, and you had these smaller sort of arrangements. And in many ways, the G20 consensus to begin with the G7 declaration, and then this OECD G20. It is some people would say that it's a comeback of multilateralism, but really, like Pallab said, to what extent this will ultimately percolate down, because we are yet to see how countries really agree on this, right, by October, and not that every country will have. I mean, because even if you look at India's demands are slightly different in terms of the thresholds at which they want the taxation to be, and so is many other countries, including Ireland and Hungary. So one has to see how the real, the greater details and meets comes out in October. But beyond, OECD G20, could this be an example now to accelerate multilateralism, not only on tax, but many other contentious issues on which, globally we have been concerned on, whether this will have an impetus to those discussions, including within the WTO? That's a question which is very difficult to answer, and I am, like Pallav, I am not very optimistic about that. For example, customs duties on electronic commerce and goods which are traded through electronic transmission. That is an issue which has been there since last 20-25 years, and there hasn't been any movement on that, right? Some developing countries, including India and South Africa, they have been demanding that why there should be, a member state should be given a right to impose customs duties on that. But the moratorium continues to be extended, and developing countries have a legitimate, right, or I would say the rationale which they have at least offered. There is some level of legitimacy there. They don't want to lose on their revenue, and particularly for developing companies, tax revenue is very important in order for them to achieve their economic development goals. Will this OECD G20 framework agreement, will that give a push to discussions within WTO on electronic commerce monitoring? That's a question which is still it's difficult to answer, but I'm quite pessimistic about that right now.
Since you brought about the role of WTO, could you elaborate on how any implications on the OECD G20 inclusive framework on existing will impact the existing trade rules within the WTO framework?
Yeah, so again, to go back to that, I mean, this can be one example where discussions around e-commerce, moratorium e-commerce can be again broached upon, and people should, perhaps member states should consider that to discuss issues. The second item again, but the challenge with WTO is while one can relook at Article 3 and one can relook at perhaps this whole discussion on tax could also accelerate discussions around trade and investment, which hasn't happened so far beyond the TRIMS agreement. But there are certain historical problems associated with WTO, and it will be very difficult to overcome that. And these are institutional problems, structural problems. And WTO was never established with a purpose to get into domestic policies of the country, right? I mean, at one level it was, but the entire premise of WTO was that I am giving you sufficient space for articulating your domestic policies, and there will be some level of agreement between countries that you liberalize trade in terms of border tariffs, right, and trade in goods and services subsequently. But there was no surrender of entire policy space, domestic policy space, to the WTO. Countries took certain sovereign rights were retained, and that was there. And domestic tax issue was one such right, and nobody wanted. I mean, if you look at the WTO dispute settlement body reports, time and again in context of Article 3, you'll find that the purpose of Article 3 is not to regulate domestic taxes, right? You have countries who do not have any income tax law, right? Are you going to say tomorrow to the country that no, you should have an income tax law? It's up to the sovereign to organize how they want to organize their domestic laws. There is some base minimum on which they agreed, and that was with trading. So that's the problem with it's a structural and historical problem of WTO. WTO perhaps will not be able to get into that, and I see a merit in somebody getting into these issues, because this ultimately, look at how it has been articulated. Even if you look at the inclusive framework statement which has come, that statement has been positioned more from an angle of tax competition, right? What they're saying is that if you have a jurisdiction which is a tax haven and you do not have sufficient taxes, you are basically luring investment into that jurisdiction, and others are not getting benefit because you have simply not taxed, or the tax is insignificant. Currently they have agreed on 15%, but this theory in itself, while looks quite attractive, within WTO realm, it can create too many problems. Now, let me give you an example. If tax competition is an issue, why is only tax competition an issue? There could be then other issues. For example, let's talk about cost of capital, right? Several countries have their own interest rates. In India, if you want to avail capital for working capital or anything else, the interest rates, I mean, COVID times may be an exception, but if COVID will go someday, and if you go to the pre-COVID world, the interest rate at which you get access to capital in India is not the same what you'll get in Europe or Japan for that matter. It's very cheap. Are we going to then say that there should be a uniform interest rate, or there should be a cap on interest rate below that which you can't lend money to businesses? I mean, those kinds of argument will come, because that's also a competition issue, right? Because if I am sitting in, say, Germany or Netherlands or some other country in Europe, the cost of production of goods for me will be far less, cheaper, less costlier than what happens in India, because the cost of capital is so huge. Now you can introduce too many variables into it. You can get into labor structure and so many other things. So is the WTO's, my question then therefore is that, will the WTO's goal would be to get into these issues? An idea was that you don't get into all the macroeconomic issues, and tax at many levels is also a macroeconomic issue, right? Because through taxation policies, you drive several other factors of macroeconomy, whether it is consumption, whether it is savings, whether it is investment. If you decrease income taxes, what does that mean? I will have more money to save on my hand. I will perhaps spend more or save more, and those are macroeconomic factors, right? So WTO never wanted to get into that. The whole idea was that somewhere I will play on the border, and the border is that when the goods are being supplied between two countries, there should not be any hindrance beyond what is agreed between the countries, and there should be a very easy flow of goods and services, and that's where they stop. So to that extent, what is happening, what has happened now on OECD base, they will give some impetus to multilateral discussion on certain pending items within WTO, but is it going to push it beyond what we know of in terms of scope of Article 3 or scope of WTO? That will require a complete overhaul of the system, to my mind, and these are quite radical for WTO. Thank you.
Just to add to Parthasarthi's point, and thank you, Parthasarthi, for making that particular point. I think one has to also look at the fact, that what the BEPS initiatives are addressing is primarily the challenge faced by the challenge created by the digital economy. The brick and mortar economy, as we call it, is has a different set of challenges again, from a trade perspective. And therein lies the divide. These tax-based issues will primarily ensure equitable collection of taxes, but will not change will not move the needle a whole lot when it comes to actual trade in physical goods.
So when we move to tax evasion, could you elaborate on how treaty shopping works?
In simplistic terms, treaty shopping is businesses just looking at whatever country offers the most lowest tax rates, and situating there, and then providing the services to other countries, to other jurisdictions from that. So to illustrate an example, if you go back to the Facebook example that I gave you earlier, Apple, for example, has operations in Ireland. A lot of these tech companies have bases either in Netherlands or Ireland because of the lower tax rates that these jurisdictions provide. In the past, we'd seen, businesses, a lot of businesses in the Indian context, situated in Dubai, so because Dubai has obviously zero tax rates, etc. So treaty shopping is in effect, taking a look at jurisdiction which has lower tax rates and then situating in that particular jurisdiction to only avail these lower tax rates without any business substance thereof.
You also elaborate on how the framework, the BEPS framework or regime is going to change the current domestic laws and in tax havens like the Cayman Islands or other countries across Europe or even.
So, I mean, the OECD framework doesn't, necessarily force these countries to change their domestic tax laws. And this is a key point that Parthasati was also making, right? The OECD framework is recommendatory, in nature, so to speak. And the impact primarily is on bilateral trade and, cross-border taxation. How these countries respond to the framework and the new situation or the new arrangement that the framework imposes is going to be is remains to be seen. That said, these countries as tax havens are not going to disappear tomorrow. They will obviously be, other users. And the BEPS framework addresses primarily large multinational enterprises. There will obviously be individual users for these tax havens as well, which will continue. And smaller businesses which do not fall into the definition of multinational enterprises can very well continue to use these tax havens without a challenge. So small and medium businesses, small SaaS-based businesses, for example, the framework doesn't really address how they are going to be, how they are going to be impacted by this particular measure. I mean, one could say, action plan one still covers them, equalization levy, etc. But again, how exactly, the other pillars of the recent announcement impact them, we'll have to see.
So, the next question will be addressed to Parth Sarthi, sir. So, could you explain what the future of a trade and tax would look like now that we have a BEPS regime or the framework? What do you think the future of, and how do you explain the interface between the future that exists for trade and tax?
Well, so look, surely if this percolates to an agreement and people do abide by this minimum tax structure of 15% or what, surely there will be some impact on movement of capital, right? If that was your question on trade, and if there is an impact on movement of capital, surely there is also going to be impact on movement of goods. So, are we going to, if the businesses don't find it optimizing enough to set up, say, their offices in Ireland, right? What does that mean? Then they don't have any incentive to go to Ireland other than what it was before, a low tax haven, right? Low tax jurisdiction. So they will then go to places where other incentives are there. So if those incentives could be, again, cost of capital, cost of labor, and all other issues of macroeconomics, whether it is land, whether it is infrastructure, and all of that. And those will be the decisive factors for movement of goods and movement of manufacturing of goods and movement of capital, because now you don't have that level of difference or that level of advantage in going to a particular jurisdiction for tax once this percolates down. But it only says minimum tax, right? 15%. There could still be a difference between 15% and say 35% and 40%, and that bandwidth from 15 to 40 or 15 to 35 is still available to play around, right? And if mathematically it seems more optimizing for me to be in a jurisdiction where you have a 16% tax or 20% tax in comparison to, say, a jurisdiction where it is 35%, to that extent movement of capital will be still one of the factors will be tax, right? So these are the two things I would assume that it will play out. Surely completely nil tax or zero tax is out of picture if this comes into it gets implemented and more countries sign up onto that. So that's how I see it getting into, and ultimately, of course, it is also going to impact the global, supply chain, right? Because the global supply chain currently is also, if you look at, uh, and that's not just tax. If you look at Vietnam and many other some Southeast Asian countries where more and more assembling and manufacturing is happening, is also part of the reason is that there are many friendly policies there, right? Uh, uh, the different taxing regime at some level had fragmented this. Now, if you get to a level where you have a minimum corporate tax, and if it is not significantly different, to that extent, this fragmentation of getting a part from this place or manufacturing at this place, supplying at other place, all of that will to an extent get dissolved. So that's another outcome which I can foresee. But all of this literally depends upon what's the margin we are talking about if we put 15% as the minimum. Maybe Pallav has some more thing to add on this.
So do you want to add something to this?
Actually, no, I think Parthasarathi has elucidated the point pretty well. So I don't think I have anything to add. But just to question, if I may, Parthasarathi, obviously, the uniform tax rates will change the flow of capital, but the other factors such as labor and land cost, etc., will still remain, right? So I mean, those will still ensure that some jurisdictions are perhaps more favorable for manufacturing, as the case might be, than others.
Absolutely, I completely agree with you. Labor, infrastructure, political stability, too many other things, right? I would also take into account investor protection rules, right? All of that. So there are a host of factors which will continue to remain. Tax, of course, was very important factor because tax is something which Pallav will surely agree with, that this is one of the key aspects. But there continues to be other factors, and that will determine movement of capital as well.
Yeah, because to give an example, India reduced the rate on manufacturing to 15% plus surcharges, and we haven't seen. I mean, obviously we've seen some movement into India, but we haven't seen the large influx of businesses that the government was hoping that this move would trigger. So obviously there are other factors also that one would need to consider for the
Absolutely.
So actually, we know that the BEPS is of major significance because the pre-existing tax strategies sort of question the fairness and integrity of the tax systems that were in place before. So now, and they also gave like a competitive advantage over companies that operate domestically. Now, since this BEPS regime is is still under contemplation and we are still having questions about it, how do you think the future for domestic markets are going to, or domestic-based companies are going to change with the BEPS regime? I think this could apply to Parth Sarathy sir as well because it's about competition and competitive advantage as well. So,
Pallav, you want to go ahead first?
why don't you take this one first?
Sure. So, Bhavna, can you just repeat your full question? Sorry, I couldn't get.
yes, so we know that basically pre-existing before the BEPS regime, the tax strategies affected the integrity and fairness of the tax systems in place. Now that we have the BEPS regime, it also sort of provides a benefit to domestic companies where multinational companies will not, will it will prevent the exploitation of the tax caps that were in place. So, do you think that now they're in an equal level footing with regard to how domestic markets will operate?
So surely, I like the entire purpose of the BPS was to bring out some parity, level playing field between, because there are large multinational enterprises who were not paying tax in so many heavens. So basically the issue was about non-taxation in any regime for that matter. Because if you are seated in India, or even if you're not seated in India, in double quotes, I'm not going to use those words loosely, but if your business, you are making revenue from India, and merely because of certain kinds of principles of tax law, you are not being taxed here, that tax is actually it's a loss, because it was not taxed even perhaps in some cases in your originating country, in some cases, whatever. Well, so to an extent, these tax, the new framework which is going to come and once applied will bring some level of parity between companies who are not so large and who are operating only within a jurisdiction for that matter, and we're being taxed there as opposed to their competitors providing again competitive products which is commercially substitutable. To that extent it will surely bring a parity, but like I said, it all depends on the devil lie in the details, and it all depends on what is the final agreement which we get to see in the in October whenever it comes, and that will really tell us to what extent this is going to actually address the issue of competition between products of domestic companies and products of multinational enterprises.
Sure, sir. Do you want to add anything, sir, further?
Yeah. So just to add to Parthasarthi's response, I'll give the example of Chinese retailers who had entered the Indian market. We saw an influx of large number of Chinese retailers who were selling, for example, clothing to the Indian market at cut rate prices, also circumventing, as Parthasarthi would Indian trade channels. So the imposition of equalization levies, for example, which is part of the BEPS plan, has already ensured that some of these players would have to pay tax in India. So definitely, this is going to lead to a level playing field as far as Indian domestic companies are concerned. Similarly, for all other countries that are part of the BEPS plan, so it would ensure that large multinationals with access to capital cannot necessarily steamroll over local enterprises.
So, we discussed earlier about how domestic laws, how this has impacted the domestic laws, about how countries are bringing about their own changes. We discussed about India. Okay, could you highlight other examples of other nations, how their governments and countries are coordinating to bring about domestic changes within their laws?
So, on the subject of digitalization, digital taxes, Parthasarthi already talked about other countries which have imposed similar levies, such as Italy. France did it. I think UK also had a similar levy that was imposed. So countries have already adopted these particular measures. Other than that, I don't personally know of any large significant measures that countries have taken in the realm of the first element of action plan one of the BEPS action plans. Trade, obviously, from a trade perspective, protectionist duties and levies have been existing for ages and will continue to exist in different countries. And Parthasarthi might be able to explain them a lot better than I can. But yes, these are the countries which have implemented digital taxes, at least as envisaged in the OECD guidelines.
Yeah, so Pallav, yeah, I completely agree. In terms of if you just look at the recent manifestations, which is only on the digital levy, what we call digital tax. In India, they call it Google tax. But that kind of taxation regimes were already being articulated by countries, right? France was an example. They never imposed it because they got into a discussion with the United States. Italy is one, and there are many other countries within Europe who have already articulated their policy space. With the EPS now coming with this inclusive framework, it's likely that some of these measures which were thought about will not be implemented, and they will wait and watch. That's also likely possible. And other than that, really, I agree with Pallav in terms of this whole disparity between large multinational enterprises and the taxation regime has not been traditionally addressed by countries. The other regimes which have been in place in terms of to protect their domestic manufacturing, those have been more from an angle of putting border tariffs or putting non-tariff measures, some sort of standardization requirement, or many other kind of tools which is available within the WTO, sometimes legally and sometimes not so legally. Countries have adopted that, but at a level of direct tax, I'm also not aware of any other instance where countries have taken anything beyond what we just spoke about, right?
Sure. So I think we can all agree on the fact that we have to see how these measures, when implemented, will make about like a big or bring about a big change. So I hope we can further the conversation when we see an effect about how the framework is working in our country. So far, it's been an excellent discussion. Thank you so much for your detailed explanation on both the tax and the trade-related perspective on building and strengthening multilateral framework, and for raising some great points and some insightful comments. I would like to extend my thanks for giving your valuable time towards indulging in such pertinent issue. And further, I also thank the audience members for tuning in and listening to the discussion, and we really value your feedback. We look forward to seeing you in the upcoming panel discussion of the Global Law Assembly. Thank you so much for joining us today.
Thank you so much, Bhavna. Thank you, Partha.
Thank you, Pallav, and thank you, Bhavna, for giving us
Thank you.
this opportunity. It was great interacting on this hot issue. And thank you, Pallav, again. Pleasure meeting you.
Sure.
Pleasure,
Yes.
pleasure, man. Thank you so much.